Hey, where are you going?
I'm just going next door. Be back in a minute.
But you can't park in my driveway.
Sure I can. I own one of the commercial buildings next door, so I'm a successor entitled to Concord Development Company.
Who the is that?
Concord Development Company built all the houses and commercial buildings in Deerhurst. My deed says nothing about it, but your deed gives me full permission to park in your shared driveway.
Are you serious?
Yes, I am. I've got the deeds right here. You see, reserving, however, unto Concord Development Company, a corporation of the state of Delaware, its successors and assigns, the free and uninterrupted right, use, and privilege of said 9-foot common driveway in common with others entitled thereto forever for driveway purposes. Our neighbor at 1707 sued us and the judge agreed. He says successors means successors in title. He also implied that it makes my property more valuable if I have the right to park in your driveway. So obviously that's what they meant when they wrote these deeds in 1946.
That's crazy. So you're telling me anyone that owns a house in Deerhurst can park in anyone else's driveway?
According to the judge, yes. We argue that successors means corporate successors, and assigns means people who were assigned the rights in their deeds. That would make more sense. You see, right here, right above that reserving clause, this is where you are assigned the right to park in your residential driveway. We're appealing the decision because the judge overlooked that part of your deed. But until that happens, I'm going to use your driveway. We only have 7 parking spaces next door and I need a place to park my car. Okay, let's say you want to build 2 houses that share a common driveway. The property line is down the middle of the driveway, so half of the driveway is on lot 1 and the other half of the driveway is on lot 2. When you sell house number 1, you're going to write a deed where you grant the new buyer the land, the house, and you're also going to give them the rights or assign them the rights to use the common driveway, including the half that is on lot number 2. And in that deed for house number 1, you're also going to reserve the rights to yourself to use the common driveway. That way, when you sell house number 2, you can assign the rights to that new owner. And that's exactly what happened in this case. House number 1 is 1699 Concord Pike, and house number 2 is 1697 Concord Pike. House number 1 originally sold in April of 1944. House number 2 sold in September of 1945. So there was about a 1.5 year period where house number 1 was owned by a new owner and house number 2 was still owned by the builder, Concord Development Company. When they sold the first house, they had no idea how long it would take to sell the second house. In some cases it was a day, sometimes it was a week, and in this case it was almost a 1.5 years before they sold the second house. If Concord Development Company had not reserved the rights to the driveway in deed number 1, they would have not been able to use that half of the driveway while they were trying to sell house number 2, nor would they be able to assign the rights to the new owners of house number 2 when they finally sold that a 1.5 years later. This is why the terms successors and assigns were used in the deed for house number 1. It allows Concord Development Company to assign the rights to house number 2, and it also allows Concord Development Company to sell their entire company and the neighborhood of Deerhurst to another developer and still retain those rights. That corporate successor to Concord Development Company, a corporation of the state of Delaware, would then be able to assign those rights when they sold house number 2. You have to remember that it takes years to build a neighborhood, and this is a great example. After they sold that first house in 1944, it took them a 1.5 years to sell the second house. During that time, Concord Development Company could have easily gone bankrupt or been purchased by a larger company, and those rights would have been lost if they did not have the term successors in that original deed for house number 1. It's also completely illogical to assume that successors means successors in title in this instance. You have to remember Concord Development built 100 houses in Deerhurst, and all those people became successors in title to Concord Development Company. That would lead to the result where anyone could park in anyone else's driveway and not just their driveway. That's why directly above the reservation clause, there's an assignment clause that assigns the right to use the driveway to the new homeowner. This ensures that the homeowners only park in their driveway, and you don't end up with a crazy result where anyone can park wherever they want. It is also very important to note that the common driveway is clearly described in the metes and bounds of both residential deeds. In this case, being located 1/2 on this lot, number 50, and 1/2 on lot number 49. The metes and bounds appear in the paragraph directly before the assignment clause. This is what gives the new owners of lot 50 the rights to park in the common driveway that straddles lots 49 and 50. It has absolutely nothing to do with the successors and assigns language in the reservation clause. This is the first mistake that the Vice Chancellor makes in his post-trial order. In number 11, he says, if the defendants were correct and Concord had truly meant to reserve usage rights only for itself and its corporate successors, the homeowners who subsequently purchased the lots would have no parking privileges in their shared driveways. Those rights instead would have remained with the corporate successors of Concord. What Concord obviously intended was to reserve the right to park in the driveways for successor and title. Obviously, the Vice Chancellor did not read any of the residential deeds we submitted. If he had, he would have realized the successors and assigns in the reservation clause has absolutely nothing to do with giving the homeowners the rights to park in their driveway. That is done in the paragraph before the reservation clause, in the assignment clause, where they grant the free and uninterrupted right, use and privilege of the aforesaid 9 feet wide common driveway, in common with others entitled thereto forever for driveway purposes. These residential deeds are very important. That's why we took the time to find them and submit them into evidence, because the same strategy of assignment and reservation was also used in the 3 triplex deeds for the commercial properties in Deerhurst. In this case, instead of 2 houses sharing 1 driveway, we have 3 buildings sharing 2 common areas. The 3 deeds for 1701, 1703, and 1705 Concord Pike are very specific in defining the 2 common areas. The front area, shaded in orange, is for driveway and parking purposes. The blue area along the side of the buildings and the rear of the buildings is for driveway purposes only. In other words, you cannot park vehicles in the back of the buildings. These 3 buildings were initially sold by Concord Development to private owners in 1946. 1703 and 1705 were sold in October, and 1701 was sold the next month in November. Just like they did with the residential deeds, Concord Development Company retained the rights to the common areas for the triplex. This gave them the legal ability to assign the rights to the new owners of the second and third units when they were sold. When they sold the triplex units in 1946, Concord Development Company retained ownership of the odd-shaped strip of land known as 1707 Concord Pike. It is wedged between 1709 Concord Pike, which at the time was a gas station, and the new triplex buildings at 1701 through 1705 Concord Pike. This aerial photo shows the existing 731 square foot building, which was built in 1962. This aerial photograph from 1950 shows the previous building, which was somewhat smaller and set further back on the property, all the way to the rear of the 1707 property, up along the walkway that connected Deerhurst to the Concord Pike. This is the 3-unit triplex building, and this is the building at 1707 Concord Pike, which was used by Concord Development Company as an office and a place to store tools as they built the homes in Deerhurst. The walkway, which is the northern border of the 1707 parcel, is shaded in blue. This photo also shows that in 1946, when the triplex was built, there was no need for Concord Development Company to use the triplex driveway to access the rear of the 1707 lot, since the building was all the way at the property line and you could not park a vehicle behind it. This photo, taken in the 1950s of 1709, 1707, and 1705 Concord Pike, shows the old building at 1707 was at least 20 feet set further back than the new existing building that was built in 1962. This meant there was more room out front for parking. Concord Development Company held on to 1707 for 34 years and sold it in 1980 to a new owner. That 1980 deed is very important. It makes no mention of the common areas on the triplex, nor does it have the assignment clause that one would expect in order to be able to use the common areas on the triplex. In addition to the fact that the 2 common areas on the triplex properties do not include any portion of the 1707 parcel, the lack of an assignment clause in the 1980 deed proves that Concord Development Company never intended 1707 to be able to use the common areas on the triplex. If this is what Concord Development Company had intended, they would have used more specific language in the 1946 triplex deeds. In fact, they had already done it. There are 2 houses in Deerhurst that share a driveway that does not straddle the property line. It's located all the way on one property. In that case, Concord Development Company wrote an express easement for the benefit of Lot 72 to use the driveway that's fully located on Lot 51. This was done 6 months before the triplex was built, so they knew how to do it. And they could have written in the triplex deeds that 1707 had the benefit of using the common areas, but they didn't, and they did not assign the rights in the 1980 deed when they sold the property. So when the average person looks at the deeds for 1707 and 1701 through 1705, It is very clear that the common areas on the triplex properties do not include any portion of the 1707 lot. And since the 1707 deed does not say anything about the common areas on the triplex, one would surmise in good faith that the owners of 1707 have no rights to use the common areas on the triplex, just as the owners of the triplex have no rights to park on the 1707 lot. And that's exactly what we thought when we bought 1703 Concord Pike in September 2011. That's why we installed a 6-foot stockade fence to complete the existing fence that already surrounded the rear triplex area. We also installed wheel stops along the driveway to keep people from parking like this and blocking our driveway. This is the second place where the Vice Chancellor is wrong in his post-trial order. In number 16, he says we were advised by Newcastle County and by plaintiff's counsel that their claim rights were contested. This is completely false. Newcastle County never told us there might be a contested easement. In fact, before we installed the fence, we went to land use and were told it was fine, no permit required. And the first word we heard from the property owners of 1707 was in a February 2012 letter from their attorney, 5 months after we installed the fence, in which she says her clients intend to operate a small auto detailing business for high-end automobiles. It is their intention to detail no more than 1 car per day, and they intend to use only those parking spaces that are in front of their building. This is funny because 2 months later they sued us for the rights to park in our parking lot and sued us for damages, saying that they could do 6 cars a day for close to $200,000 in lost business revenue. The Vice Chancellor denied those damages, but he did award fees and costs, saying we acted in bad faith when we installed the fence. He compared us to a 1994 H&H Brands farm case. If you read that opinion like I did, you'll see it's about an easement, but it's very different than our case. In H&H Brand, there was a well-documented multi-year dispute about the easement. The defendant in that case was told many, many times that he could not use the easement, yet he went ahead, plowed under the neighbor's field, and started building a new road. That's bad faith. In our case, when you look at the deeds, it is not clear or obvious that 1707 has the rights to use the triplex common areas. In fact, it's more clear that they do not, since the areas are not described in the 1707 deed and there is no assignment of rights in the 1707 deed. That is why we acted in good faith when we installed the fencing. The Vice Chancellor also said in his order that our testimony for installing the fence to increase security was not credible because the fence does not attach to the 1707 building. As I testified to in court, I wasn't about to trespass on another man's property and attach a fence to his building. You can see from this photo taken prior to the installation that the triplex properties are easily accessible from the neighborhood over a short, flimsy chain link fence. The new fence may not be perfect, but the visual deterrent slows down the abuses and shenanigans we all face on the Concord Pike. I'm sure the Vice Chancellor doesn't understand this because he's never had anyone sleep behind his building, paint graffiti on his building, throw their trash in his dumpster, or have his air conditioner stolen in broad daylight. The fence increases security for all the buildings at the corner. Because the Vice Chancellor awarded fees and costs, the owners of 1707 have used the opportunity to collect as much money as they can for everyone they know. They recently submitted just over $165,000 in legal fees and costs. More than what the 1707 building is worth, and more than double what we've spent defending ourselves against this frivolous lawsuit. We will let you know if these fees and costs are found to be reasonable, but until then, continue to ask yourself, where will they park? And follow our website at www.wherewilltheypark.com.